And then the second, we do have a second of questions that then obviously flows from that, and this deals specifically with then once again criminal conduct and crime and tenants. But this one deals specifically where a landlord discovers that the tenant actually then has a criminal record, right? And what can the landlord sort of elect to do, which is within the legal realm, of course. And if they do perhaps choose to maybe cancel the lease agreement due to that information becoming viable, does that then amount to discrimination? And if it is discrimination, obviously not all discrimination is actually illegal or whatever. So is it legal discrimination, and what's the basis, and what does the Rental Housing Act or relevant legislation say? Especially if there is an agent that was involved, what does their liability look like in terms of that, if they're the one that obviously put the tenant into the property? So maybe guys, just to finish off this question and this part, just touch very briefly on those, please, Ross.
Perfect. So I like that you mentioned the Rental Housing Act, because that's obviously our starting point on something like this. So in South Africa, we obviously have the Rental Housing Act, and there's a beautiful provision in the Rental Housing Act, which is at Section 4, which basically says that in advertising and letting a property, the landlord is not entitled to discriminate, and it sets out an extensive list of items which you as a landlord can't discriminate against your potential tenants against. And it includes race, gender, sex, marital status, sexual orientation, ethnic group. It's a long list of things, and it covers a whole bunch of bases. It's a beautiful provision. It's very important for rental housing within South Africa. But what is interesting is out of all those items that have been listed there, which a landlord is not able to discriminate against, past criminal prosecution or whatever the case is not actually included as one of those particular provisions for grounds that you can't discriminate. So the Rental Housing Act is specifically in respect of residential rental property, leaves that question open. Okay, it doesn't say that you can't discriminate on that basis. So it stands to reason that there might be a basis upon which a landlord can say, look, I would prefer that I don't have someone who's got a criminal record in my particular property. Okay, whether that's reasonable discrimination, it might be questionable depending on the circumstances of the case. It would be a crazy thing for a landlord to sort of discriminate that someone has a criminal record because maybe a drunk driving charge. That might be a bit far-fetched to say, well, I'm never going to rent you a property. And the tenant might have a grounds there to say, look, that's an unreasonable discrimination in the circumstances, but certainly it's not assumed to be unreasonable in the circumstances by virtue of the Rental Housing Act. So you'd have to establish that, through a process. And I just can't see a tenant, going through the process of trying to establish with, approaching a court to say, look, they're unreasonably discriminating because of this, drink driving charge that I have. So that's sort of the baseline, that there's a question there about what this sort of conduct is. When it comes to estate agents, that's a whole different question. Now, estate agents, obviously, they've got to watch this provision as well, Section 4 of the Rental Housing Act, and we do get questions where estate agents come and they say, look, I've got a landlord and they have said that they want this particular type of tenant, be it race, ethnic group, religion, or whatever the case is. And as estate agents, we obviously have a lot of estate agents who watch these videos. You've got to be so careful. Do not fall into this trap where you start advertising and try and get this tenant where the landlord has given you a specific instruction. I want this type of person. You can get yourself in a lot of trouble by facilitating it. If you fall in a situation where your landlord says, I want X kind of person in my property, let go of the mandate. It's simply not worth it from your perspective, from a professional's perspective. But what's interesting about this, because it doesn't fall within the ambit of the act, is this could be one of those circumstances, I think, where a landlord gives you a specific mandate, and the mandate says, well, look, I want you to specifically look at past criminal prosecution or whatever the case is. What does their criminal record look at? It would have to be something very specific, because I haven't seen too many mandates which mention this specifically, so it'd have to be something really mentioned by the landlord. And in those circumstances, you're well within your rights to then, you find out what their criminal record is for any potential tenant that you're looking at, and obviously present that information through to the landlord. I think, remember, it's very important that the agent doesn't select who the tenant is at the end of the day. That's still the duty, that's still the right to the landlord to select who they actually want. You as the agent present the information as best you can in the circumstances. So if you do have that provision, I think, where the landlord has said, this is a specific thing for me that I find very important, I don't want anyone with a criminal record, you've got to now follow that. If you fall foul of that, you're falling foul of your duties, obviously. And if that's something that's not really agreed, I can't see why automatically as an estate agent you would have that obligation. Bruno, I'm not sure if you agree.
No, absolutely. And I mean, you divided the question well into two parts. So it's the question of whether a landlord, be it through an estate agent or himself, can discriminate. And in South Africa, there is such a thing as fair discrimination. It is. Discrimination isn't all bad. I mean, you don't let minors into movies. That's, it's discrimination, but certain movies minors can't watch. Certain areas people aren't allowed into. I mean, men aren't allowed into women's bathroom, although, yeah, nowadays that's become a topic of debate, but we're not getting into that. But that there's certain things, and that's fair. It's fair to discriminate in very specific ways. Honestly, between you and I, if I'm renting a unit that's on my property, I'm going to be very sensitive to criminal conduct. Very, very sensitive. I mean, some of our legislation goes so far as to discriminate in the legislation to say that if a person has ever been convicted of fraud, they're not allowed to hold certain positions. Why? Because certain positions that deal with money or trust or whatever the case is, if they've been convicted and found guilty, they're not in a good standing to hold positions that require inherently trust and the like. But you understand that there's a level of justification behind everything. So it's, and like Nick correctly pointed out, it's not drunk driving, although even there you could turn around and say, well, the person had complete disregard for the law. And it's not the type of person, I mean, if he has disregard for the law and he's driving around drunk, why would he look or take care of my property? So it's not far-fetched that even lesser charges or less serious charges in somebody's eyes, isn't going to feel serious for them. But if they've got a reason, they've got a reason. It's not discriminatory in terms of the act and inherently, so the act doesn't specify it. It could always still end up being a human rights issue depending on how far people are going to go with it. But I mean, that's obviously a conversation for a different day. So can it be done? Yes. I would just basically base it on some kind of sound reasoning. Now, can you hold an estate agent responsible? It depends on the scope of the mandate. If the mandate was specific, if the estate agent represented that they're very sensitive to any sort of criminal record and they will immediately disclose it, I would probably ask, was this an expectation? Did the agent do the vetting that the agent had promised to do and failed to recognize this? Or failed to do this and ignored it, because that is serious enough for the landlord to be upset, to say that there's been some sort of breach of mandate. So as an agent, I'd be very careful what you disclose, how deep your vetting goes, because the landlords need to understand this. They need to understand how far you go. So be clear about it. This is what we do. This is why we charge 600 Rand, is we do a full bank verification. We do criminal checks. We do all of this, or we don't, because it costs extra money. But don't get into a position where you don't verify the guy's bank account, or you don't verify the balance in his bank account or something. And then later you say, oh, but it's not something we normally do. If it's an expectation, it could get you into trouble, because then you've created a gray area. Change your mandates, list exactly what your vetting entails, and that will at least manage the expectations.
100%.
Yeah.
Yeah, thank you very much, guys. 2 questions dealt with quite nicely and in depth there. And then once again, just to conclude, this again goes back to the importance of understanding your responsibilities and your roles and your obligations once it comes to the contracts that are involved in the property industry. So the estate agent, landlord, or tenant, it's to keep up with legislation, read through contracts, get the proper advice. That way, you understand and you sort of know what your recourse and remedies are throughout. And then thank you guys for both those questions, those answers, and the value of the knowledge again. Thank you for everybody. If that is it, of course, thank you everybody for joining us today, and we'll see you again next week for more questions and answers.
Cool. Awesome. Thanks so much, guys.
Cheers.
Cheers.